The trial between the United States government and Google is underway. What's the complaint? That Google has been unlawfully engaged in anti-competitive behavior to maintain its dominant position as the world's leading search engine. Today, we'll give a bit of an overview on the charges and what has transpired in the case so far. Lastly, we'll talk about why this antitrust case is big stakes for both the government and big tech. The antitrust case argues that for many years, Google has used anti-competitive tactics to maintain and extend its monopolies in markets for the general search services, search advertising, and general search text advertising. For years, Google has entered into exclusionary agreements, including tying arrangements, and engaged in anti-competitive conduct to lock up distribution channels and block rivals from gaining any sort of substantial market share. They do this by paying billions of dollars annually to lock up the default search rights for various different device manufacturers such as LG, Apple, Samsung, Motorola, and wireless carriers like AT&T and Verizon, and browser developers like Mozilla and Opera. The government argues that the default rights are important because users largely stick to the default search engine despite having the ability to change it. So in essence, the default search engine has sort of this de facto exclusivity. Now, these exclusive agreements cover approximately 60% of all general search queries, and Google's own channels, such as the Chrome browser, account for another 20%. So based on its agreements and its own tools, they account for 80% of all search queries that are made. The lawsuit notes that they also take an additional 10% share, presumably from consumer preference, to control 90% of the general search query market. Google sells advertising on their search results, and the lawsuit alleges that Google makes $40 billion annually of advertising revenue, which it then shares with the other parties that they have set up these default and exclusionary agreements with. In essence, they are paid and incentivized to keep those deals in place. And the lawsuit alleges that these massive payments keep up barriers to entry that smaller search engine companies could not possibly afford to pay to these different device carriers and channels. Notably, the lawsuit calls out the antitrust case of 20 years ago, United States versus Microsoft. In that case, the court recognized that Microsoft's actions of requiring preset default status and making software undeletable were exclusionary and unlawful under the Sherman Act. Now, the US government is trying to make the case that Google is doing similar actions with the general search markets. If I've made a good case for your enjoyment, then please hit the like button and consider subscribing for more business and economics content in the future. Now, to the current events, as I've mentioned, the case is currently ongoing, and many high-profile players have been taking the witness stand over the past couple of weeks. We've seen Microsoft CEO Satya Nadella take the stand, as well as the CEO of DuckDuckGo, Gabrielle Weinberg. They have been providing context on how dominant Google's position has been in the marketplace. There are several different emails and conversations submitted into evidence that talk about how Google's exclusive deals will squash all competition or innovation. Microsoft was prepared to take a multi-billion-dollar short-term loss in a deal that would see Apple replace Google with Bing as its product's default search engine. But Apple said no, presumably because they make billions of dollars from the information services agreement that they have set up with Google, which is essentially their exclusionary rights to being the default search provider. In fact, it's estimated that that information services agreement is worth $18 to $20 billion in annual payments from Google to Apple, which would account for about 15% of Apple's annual operating profits. A large chunk of money. Now, I am not saying that Bing is a better search product than Google, but it just goes to show how sticky and pervasive these search exclusionary deals can be when so much money is on the line. There's a lot of information about how Google has been careful about talking about market share or competition to not leave an evidence trail about any sort of discussions around that. That has some merit, but to be honest with you, any large corporation will have sort of these compliance trainings that talk about how you should speak or talk or write. And I don't know that in the grand scheme of things that means anything that you should be concerned about. It just seems more like standard business practice these days. So I'm not sure that's the best argument that the government has against Google. But they do go on to talk about how Google's current CEO said back in 2007, before he was CEO, that, quote, "I don't think it's a good user experience, nor the optics is great for us to be the only provider in the browser option." A lot of them are sort of painting this picture that Google is the lens through which the internet runs. It's no wonder that Google has become a verb for searching the internet, that you can start to ask a lot of these questions about, do they have monopoly power? The last interesting thing I've seen come up in the trial so far is kind of around the advertising auctions that Google holds. So Google holds these auctions where people can bid for different spots to show you advertisements based on different keywords. And Google has essentially admitted to quietly tweaking advertising auctions to meet revenue targets, sometimes raising ad prices as much as 5 to 10%. And this is sort of an argument that the Justice Department is starting to paint, that if Google can raise ad prices without facing significant competition, it could strengthen their argument that Google holds this illegal monopoly, especially over the advertising space on general search. So we've talked a lot about the allegations, but what is Google's defense? Well, their defense largely rests on the fact that they have a superior product. They argue that the users have a choice, and they've resoundingly chose Google because it's the best. And if their crime is being successful, then, well, I guess they are guilty. As for the exclusive rights contracts, well, they argue those are bid out in a fair competition process. Any of their other competitors could offer Apple billions of dollars and ad revenue sharing deals just like them, right? Except that we saw that Microsoft did offer more money and they didn't get the deal. So maybe Google does have the superior product, and I would argue that at this point in time, they probably do. But the whole point of an antitrust case and monopoly is that once Google has become a monopoly and maintained their position, then they can squash anyone else from coming into the marketplace. So you won't see a better product come into the marketplace because they don't have the money that Google has and can't offer these deals, and thus they never gain traction, which is the whole point of this lawsuit in the first place, is that Google is stifling competition. So this leads us to the stakes. Antitrust cases always have the potential to be massive market shakers. If Google is found to be exerting monopoly power, the remedial steps to fix that can create a lot of opportunities for new companies to rise up. And competition is a good thing, because when companies have to compete with one another, that encourages innovation and market-based pricing. Often these giant companies get large and complacent, and the end result is poor results for the end user. So I'm looking forward to hearing more about the details of the case and what the outcome will be. We are likely to get verdicts in 2024, so these things do take their time to get through the legal system, but that's okay. We want to make sure that things are judged appropriately and fairly based on the laws we have in place. If you like this video, then consider checking out the one on the screen now. Thanks for watching, and I will see you in the next one.